Welcome to The Explainer. Today we're diving into a massive change in India's justice system, the brand new rules for getting bail. We're going to break down Section 480 of the new Bharatiya Nagarik Suraksha Sanhita, or BNSS, to understand what it really means when someone's accused of a serious crime and wants to get out on bail.
So let's just jump right in with the biggest question of all. If you're accused of something serious, is getting bail a basic right that you're automatically entitled to? Or is it, well, a lot more complicated than that?
The entire system really hinges on one single crucial difference. Is bail a right, or is it up to the court's discretion? And that distinction, that single point, is what decides whether a person waits for their trial at home or behind bars.
Okay, so you can kind of think of it like this. There are two totally different tracks. For the less serious stuff, the bailable offenses, getting bail is pretty much automatic. It's your right. But for the serious crimes, the non-bailable ones, it is not a right at all. Suddenly, it's a judgment call that the court has to make based on all the facts of the case.
But hold on, it gets even trickier. Even when a judge has the power to decide, the new law puts in what you could call hard stops. These are situations so serious that the judge's ability to grant bail is basically taken off the table.
So what are these hard stops? Well, there are two main red flags that will almost always mean a court says no to bail. First, if there's a good reason to believe the person committed a crime that's punishable by death or life in prison. And second, if that person already has a track record of being convicted for other serious offenses.
Now, when we talk about a person's criminal record, the law gets really specific. It's not just a general vibe check. It actually tries to measure the level of risk someone poses by looking at a very clear timeline of their past actions.
And here's how that breaks down. It's actually pretty black and white. If you've been convicted of just one previous offense that was punishable with 7 years or more, life or death, then no bail. Or if you've been convicted of 2 or more previous offenses that were punishable with 3 to 7 years, again, no bail.
Okay, so with all these strict rules, you might think there's no flexibility at all, but that's not quite right. The law actually builds in some incredibly important exceptions for humanitarian reasons. You can think of them like safety valves in the system.
So yeah, even with those rules that seem completely set in stone, the law creates a little bit of breathing room. In certain situations, a court can still decide to grant bail, even if the crime is really serious or the person has a prior record.
And these exceptions are specifically designed to protect vulnerable people. The law basically recognizes that for a child, a woman, or someone who is sick or frail, the harm of keeping them locked up before trial might actually be greater than the risk of letting them out. It's about compassion.
And get this, there's even a very narrow path for people who have a criminal record. Bail can still happen, but, and this is a big but, only if the court finds that there are just and proper special reasons for it, and they have to write those reasons down. It's a really high bar to clear, but the door isn't completely shut.
All right, so let's say the court decides to grant bail. That doesn't mean you just walk free, no strings attached. Oh no, that release comes with some very strict, non-negotiable conditions. For anyone accused of a crime that could get them 7 years or more in prison, these 3 conditions are absolutely mandatory. You have to promise you'll show up to court every time. You cannot commit a similar crime while you're out on bail, and you absolutely cannot mess with the evidence or try to intimidate witnesses. But, this whole process isn't just about the person accused of the crime. The law also lays out very clear procedures to make sure the process is fair for everyone, ensuring the state gets to make its case and that the court's final decision is totally transparent.
In fact, for the most serious crimes, there's a key procedural step built right into the law. A judge can't just make a decision on their own. They are legally required to hear from the prosecution before they can say yes or no to bail.
And that's where the public prosecutor comes in. In any case that involves a potential punishment of death, life imprisonment, or 7 years or more, the court must give the public prosecutor a chance to be heard. This is to make sure the court has the full picture before making a call that could impact public safety.
And to keep everything accountable, the law requires something called a speaking order. This is so important. It basically means the court can't just say bail granted or bail denied. They have to provide written reasons explaining why they made that decision. This ensures that their judgment can be reviewed and that decisions are based on solid legal reasoning, not just a gut feeling.
So when you step back and look at the whole picture, the tough rules, the compassionate exceptions, the mandatory conditions, and all the procedures, you start to see what's really going on here. The whole system is a really careful, really delicate balancing act between two huge principles.
And that really brings us to the fundamental dilemma at the very heart of criminal justice, doesn't it? How do you protect one person's freedom before they're even proven guilty, while also making sure that society as a whole remains safe and secure?